Hello, I'm still Stephen Gold. Did I mention to you what I reckon to be the perfect gift for Christmas,
If you're
for
about to
holidays,
plug the
for
return of
birthday?
breaking law, please get on with it.
Mediation. Well, that's a process by which an independent person who's been trained in getting parties at war to settle their differences will apply their skills to you and your opponent. Bang your heads together ever so delicately to avoid too many fractures to the skull and hope you reach a settlement. In county court small claims cases, there's a free mediation service for most claims not involving more than £10,000, where the mediation is normally by telephone, but it isn't available for a dispute if no court proceedings have been started. Up until now, small claim or big claim, mediation hasn't been compulsory. Very often, parties to a dispute will reject the idea of mediation because they want their day in court, or they think they can beat down the opposition as the paperwork stages of a case progress by being aggressive rather than conciliatory. And anyway, mediation costs money, apart from the small claim scheme. And if the prospects of mediation being successful are reckoned to be non-existent or small, well, why waste this money on top of the costs of the court process? From the court's point of view, mediation is the best thing since sliced panettone. If the case never starts in court or it settles after court proceedings have been brought, the problems of the big backlog of cases will be erased, or not aggravated at least.
So why not make mediation compulsory?
A good question for a change, because there was a Court of Appeal case about 21 years ago which appeared to say there was no power to make mediation compulsory.
Did it say that?
Well, everybody thought it did.
But did it?
Well, no. Well, let me put it this way. It did say it, but what it said wasn't binding for certain legal reasons, so we can forget what it said, or we thought it said, forget about the thousands of cases that could have gone to compulsory mediation over the years, and start all over again. Yes, in a new case, Churchill and Merthyr Tydfil Borough Council, just before the Court of Appeal, and a strong Court of Appeal, including the Lady Chief Justice and the Master of the Rolls, it was held that a judge can order parties to enter into mediation even though one of them, both of them, or all 23 of them, if there are that many, object after all. It might be thought that any party who does object won't have their heart in it, so what's the point? But you never know. Before mediation will be forced on the parties, says the Court of Appeal now, the judge must be satisfied that it is proportionate to do this, bearing in mind the aim of settling the dispute fairly quickly and at a reasonable cost. And it will be made clear that if mediation is unsuccessful, then the case will proceed to a full hearing in court. No absolute rules will be laid down for when compulsory mediation will be ordered. The specifics of each case will be looked at. My bet is that we'll see quite a few compulsory mediations ordered in small claims, where you may have to wait for up to a year to get a contested claim heard if it doesn't settle. And in small and big claims, it's always open to parties to take the initiative and organise mediation themselves before or after a case is started. The Civil Mediation Council maintains a list of mediators and runs a fixed fee scheme for the more straightforward claim. The higher its value, the more you pays. For example, if a claim has a value of between £5,000 and £15,000, a 3-hour mediation session by phone or video will cost each party £320.
What happens if one side is ordered to mediate but refuses?
Well, the court will halt the case. If it's the claimant who refuses, the claim will be paralysed until they cooperate. Ultimately, it could be thrown out. If it's the defendant who refuses, they could be debarred from defending the case, and either refuser could end up having to pay the other side's costs. Now, we've been talking about civil cases only. The Court of Appeal's ruling does not apply to family cases. There, in the family court, for some time there's been a degree of mediation type activity required. Not much though. Generally, you'll be prevented from starting an application relating to finances and property or the care of a child unless you've previously found out about how mediation works by attending a mediation information and assessment meeting. But there are a number of exceptions to this requirement. They're the current requirements. Do you need to mediate or attend one of these meetings in order to bring divorce proceedings?
Surely, yes.
Positively, no. Incidentally, the position in non-divorce, which I've outlined in family cases, is going to change on the 9th of April 2024, with more of a push towards mediation. But we'll look at this closer to the changes coming into force.
Oh no.
Oh yes, we know how to make you suffer on Law Watch.
And pick yourself up, dust yourself off, and start all over again.